When people write a contract, they often include a clause that calls for damages to be paid in the event of breach. But sometimes it's hard to say how much actual damage would occur. In that case, the parties might call for liquidated damages or stipulated damages, which represent their best estimate of damages that would occur from a breach. In Muldoon versus Lynch, a widow, disappointed in how long it took to ship marble from Italy to California, tried to invoke liquidated damages to get out of paying for most of her husband's monument. Margaret Lynch entered into a contract with M Muldoon to provide grading, brickwork, sarcophagus, and a monument of Italian marble for her late husband's grave. The price of the total project was $19,000, paid in 4 small installments during the work, and a remaining balance of nearly $12,000 upon completion. The contract contained a clause stating that all work, except the monument, was to be done within 4 months of signing. The rest would be completed within 12 months, quote, under forfeiture of $10 per day for each and every day beyond the stated time for completion, unquote. Muldoon procured the monument in Italy, but ran into shipping difficulties. The monument consisted of 4 large blocks of marble, one of which weighed 20 tons. The only way to get these blocks to San Francisco was by ship, and there weren't any ships sailing between Italy and San Francisco. Muldoon had to wait 2 years for a ship that could transport the marble to its destination. As soon as the monument arrived in San Francisco, Muldoon set it up. Lynch refused to pay Muldoon the balance of the contract. Muldoon sued. Lynch argued that the actual damage that would have resulted from a breach was impossible to ascertain, and the $10 per day were intended as liquidated damages. She claimed she was permitted to deduct that amount from the sum she still owed Muldoon, making her payment just $4,000. Muldoon countered that the $10 a day forfeiture was a penalty, not liquidated damages, and Lynch couldn't set it off against the contract price without proof of actual damage. The trial court found for Muldoon. Lynch appealed to the California Supreme Court.